Welcome to the 17th Congress of the International Association, you see, of Jewish Lawyers and Jurists. I am Pnina Sharvit Baruch. I am the Vice President and Coordinator for International Organizations at the Association. This is our 17th Congress, but our first virtual Congress. This is, of course, because of the pandemic that has transformed our world and made 2020 a very unique year. And of course, we miss the personal meetings, the ability to meet everyone here and meet in person. But there are also upsides to this pandemic, and one of them is that we have this year a record registration of 400 people who have registered to this conference from 27 countries. From different countries, different areas of the world, and different time zones. So, hello, bonjour, bonsoir, buenos dias, bom dia, buenas noches, let me see, dzień dobry, yo, napot, and maybe I should stick to shalom, to everyone that has joined us in this conference. I promised you we have a very interesting conference with fascinating speakers who are going to share with us the most topical issues of the day. Technology is great, and as you can see, I have lost my earphone, which is an example to the fact that we might have glitches during this conference. We try to have everything go as smooth as possible, but we apologize in advance and ask for your patience and understanding if we do have some technological glitches. And now, it is my honor and my pleasure to invite the association's president, Advocate Meir Linzen, to give an opening introduction. On a personal note, I have known Meir for over 30 years, and I have yet to figure out how he manages to do everything he does in 24 hours a day. I think he has some patent of how to extend working hours. So, Meir, the floor is yours.
Thank you, Pnina. Good morning, good evening. That's a special thing in a virtual event. I'm honored to open the 17th Congress of the International Association of Jewish Lawyers and Jurists. I would like to begin thanking the many special individuals who are taking part in this Congress, offering greetings, delivering addresses, or participating in events. I will name only very few. Mrs. Omer Yankelevich, Minister of Diaspora Affairs, Dr. Avichai Mandelblit, Attorney General of Israel, Advocate Avi Chimi, the head of the Israeli Bar Association, Ellen Carr, the U.S. Special Envoy to monitor and combat anti-Semitism, Dr. Roy Scheindorf, Deputy Attorney General for International Law, Honorable Ewan Kotler, Chair of the Raoul Wallenberg Center of Human Rights, former Minister of Justice and Attorney General of Canada. Of course, I would like to thank the members of our executive from Israel and the diaspora, and to the members of the board, to the staff, and to our friends and many members, guests from Israel and overseas. A year ago, we marked the Jubilee, the 50th anniversary of establishment of the International Association of Jewish Lawyers, which was established 51 years ago in Jerusalem. Today, the IJL is the leading Jewish legal organization in the world. I'm proud to be able to continue the way of the presidents of the association since its establishment, legal giants, the fighters for legal rights of the Jewish people and the state of Israel. I was elected president of the IJL exactly 3 years ago in the 16th IJL Congress. It was and continues to be a great honor for me. But in the same time, this honor involves a heavy responsibility to defend our people and our country. For me personally, this is first and foremost an obligation that I owe to my late parents, Ita and Mordechai Linzen, may their memory be blessed, who were persecuted in ghettos, in labor camps, in Nazi extermination camps in Poland, and who lost hundreds of their families killed by the Nazis. My parents had no one to turn for help during that terrible time, but they managed to survive, to see the establishment of the State of Israel, to make Aliyah to Israel, to marry and to establish here a family. I am the son of brands pulled from the fire, and I feel an obligation to perpetuate the memory of the Holocaust, to fight against anti-Semitism whenever it may be found, and to fight against attempt to delegitimize the State of Israel. As president of the association, I was honored to take part in the events commemorating the 55th anniversary of Warsaw Ghetto Uprising, as well as the 57th anniversary of the liberation of Auschwitz. My late mother, Ita Linzen, née Weissman, was deported to Warsaw Ghetto and was sent as a prisoner to Auschwitz. As I have mentioned, during the 3 years that I have served president of the association, I've continued the distinguished line of past presidents of the association. I will mention here only my immediate predecessor as president, Mrs. Irit Kahan, who gave me the opportunity to get to know this special organization, prepared me for my responsibilities as president, and has supported me throughout. Each president has his or her own personality and his or her own focus. I focused during my presidency on legal proceedings in national courts, both civil and constitutional courts, and in supranational tribunals in Europe, the EU, and international, the ICC. At the same time, we have continued the active representation of the association in other international forums, and in particular the forums in the United Nations. I will not take up a lot of time with details of the specific cases which we have dealt with. Some of my colleagues will do it later, but I will point out the main issues that we have been involved in. Proceedings in the Polish Constitutional Court against the Polish law. Proceedings in the United States Supreme Court together with our American Association in connection with the restoration of Jewish property in Hungary. Proceedings in courts in Europe, and in particular in Poland and Italy, against instances of anti-Semitism and defending from persecution those who are fighting anti-Semitism in these countries. Legal proceedings against anti-Semitic incitement on social media in Germany as a model for similar activities in other countries. Proceedings in the European Court of Justice against legislation in Belgium outlawing kosher slaughter, shchita, as well as Muslim halal. Filing a complaint in the International Court, ICC, in The Hague against the Palestinian Authority, its president and senior members of the Palestinian Authority in connection with the funding of terrorist prisoners and families of terrorists. Filing a position paper with the ICC against the possibility of proceeding against Israel for war crimes. I am submitting my candidacy for additional term as president of the association. If I am elected, I will continue the line that I have been following, namely to focus the activities of the association on legal proceedings in the fight against anti-Semitism and in defense the legitimacy of the State of Israel. I would like to review briefly with you my outline for the main activities of the IGL for the coming 3 years. This is a program based on continuity of current activities as well as developing new areas and points of emphasis. First, for continuity. 1. We will continue all open proceedings in various jurisdictions, including in Strasbourg and in The Hague. 2. We will initiate further proceedings in the war against anti-Semitism, focusing primarily in Europe, but also including other regions such as South America. 3. We will increase significantly the legal proceedings that we undertake against anti-Semitic incitement on social networks. But I also want to focus on a number of new projects. 1. The security of Jewish communities. Many organizations make an important contribution to the physical security of Jewish communities. We want to make our contribution by establishing a robust and efficient legal framework which will provide a legal response to the physical and verbal attacks, even minor attacks against Jews in both large and small communities. We're currently working on a pilot that will take on this challenge in a number of communities. 2. Broadening the scope of our activity against national anti-Semitic activity. A. We will take legal means to oppose activities in various countries, whether or not they are strictly defined as anti-Semitic. For example, we'll take steps to oppose legislation limiting traditional Jewish customs, which represent an essential feature of our religion and our nationality, such as Brit Milah, circumcision, and Shchita, the ritual slaughter. B. We will oppose legislation limiting the restoration of property belonging to Jews who were murdered or forced to flee their homes during the Second World War or later. 3. We will wage legal warfare against the activities of the Islamic Republic of Iran aimed at the destruction of the Jewish state. I begin here by saying that the Jewish people have no history hostility with the Iranian people. On the contrary, there has been long historical friendship between the two people dating back on the times of King Cyrus. There is also no historical hostility between the modern state of Iran and the state of Israel. Our two countries are geographically distant, and there have been no direct conflict between our two states. There have been many issues of mutual interest, but an essential ideological platform of the regime in Iran is the destruction of the state of Israel as the state of the Jewish people. The destruction of what they call the Zionist entity, if it were to come about, God forbid, would be a catastrophe in the history of our people, perhaps the greatest in history of mankind. In 1933 and the years followed, few believed that the words and the actions of Hitler and Nazi Germany would lead to the genocide of the Jewish people. We have to assume that the words and the actions of the regime in Iran would, if their leaders could carry out their plans, lead to the destruction of the state of Israel and many of its inhabitants. We must not assume otherwise. We cannot assume that what is said in Tehran or in Qom is mere rhetoric, and that what is taking place in the nuclear facilities, in the missile bases in Iran and elsewhere, in the activities of Iran proxies throughout the Middle East are not part of a plan aimed at destroying the people of Israel. We are a small organization without weapons and even without diplomats. But as an association of lawyers and jurists, we have to fight for the legal rights of our people and our country in order to prevent further genocide. The incitement and the activities of Iran against the state of the Jewish people already today contravenes the Genocide Convention. Let us continue the path of the late Hirsch Lauterpacht, Raphael Lemkin, and René Cassin, and let us fight with the moral and legal weapons that we have available against the evil which may, God forbid, come about. We are fully focused on preparing an action plan for this legal battle. All that remains for me is to wish you and your families health and tranquility, and to wish us all an enjoyable Congress. Thank you very much.
Thank you, Meir. I am now honored to turn to the Minister of Diaspora Affairs, member of Knesset, Omer Yankelevich, to say some opening words.
Shalom lekulam. Effective use of the law is a vital tool to combat the rising threat of anti-Semitism and to ensure the religious freedom of Jews worldwide. As such, it is my honor to join this international gathering of Jewish lawyers, jurists, and legal experts. This community works from a local to global level to advocate on behalf of the Jewish people and human rights. The International Association of Jewish Lawyers and Jurists is the Jewish people's first legal line of defense. Your work is central as anti-Semitism spreads through legal avenues. Jewish rituals such as circumcision and kosher slaughter in European countries are under legal threat. Anti-Israel bias remains a constant at the UN and ICC. The dedicated and often behind-the-scenes work of the IJL is central in defending the Jewish community in these spaces. It takes a network to fight a network, and we are in this fight with you. The Ministry of Diaspora Affairs leads Israel's efforts to ensure Jewish life outside of Israel. We monitor anti-Semitism online and offline and support the resilience of Jewish communities worldwide. Together, Israel's Diaspora Ministry, the International Jewish Legal Network, and our partners make up a global coalition that works to ensure the physical and spiritual safety of Jewish communities. I thank you for your important work. By joining our efforts, we create a safer, more just society for the Jewish people and world at large. Toda rabba.
Thank you for these important words. And now I am excited to invite the Attorney General of Israel and my ex-commander, Dr. Avichai Mendelblit, to share his message with us.
MK Omer Yankelevich, Minister of Diaspora Affairs, my friend Honorable Erwin Kotler, former Minister of Justice and Attorney General of Canada, my friend Advocate Avi Chini, President of the Israeli Bar Association, Advocate Meir Linzen, President of the International Association of Jewish Lawyers and Jurists, Advocate Colonel Retired Daniel Weisner, Ijl Vice President, Advocate, also Colonel Retired Dina Sharvit Baruch, Ijl Vice President, dear friends, guests, and colleagues. It is my pleasure to take part in the 17th Congress of the International Association of Jewish Lawyers and Jurists. Unfortunately, we do not have the pleasure of holding this conference here in Jerusalem and meeting in person. Yet it is still wonderful to see so many of you joining virtually from around the world. Technology has allowed us to make the most of this difficult situation and bring together friends and colleagues for occasions such as this fascinating conference. The COVID-19 pandemic has brought on new challenges and has enlightened existing ones. In times of hardships, it is often the unfortunate case that divides voices, and voices laden with xenophobia are heard more loudly. This is also true for those working to delegitimize the state of Israel and those promoting anti-Semitism. In these trying times, Our joint strengths as a community is even more important. Despite these challenging times, we have witnessed important developments in our region in recent months. Israel has expanded its community through the Abraham Accords between Israel and the United Arab Emirates and between Israel and the Kingdom of Bahrain, as well as through the joint statement of the United States, the Republic of Sudan, and Israel. These agreements and alliances signify the deep change that we are witnessing in the Middle East, the positive effects of which we echo for many years to come. Notwithstanding these positive developments, the State of Israel and the Jewish people are still battling attacks against Israel and acts of anti-Semitism. Ijl has been on the forefront of this battle since its establishment, and I'm always impressed to learn of its work. Ijl works tirelessly to advance human rights and combat anti-Semitism before UN bodies, domestic courts, and other international fora. Ijl's Legal Center for Combating Anti-Semitism has taken on important issues such as the battle against anti-Semitism and hate speech on social networks. I was especially interested to learn of the work being done in Germany, where lawmakers have implemented important legal measures concerning hate speech, based on which the center has been persuading social media companies to remove anti-Semitic posts. In this past year alone, the association has been involved in a number of important legal cases brought before international courts. The association has put forward its position before the Court of Justice of the European Union on the issue of kosher shchita. It also filed an amicus brief before the International Criminal Court, arguing that the ICC lacks jurisdiction of the so-called situation in Palestine. Last year, I published a legal memorandum on the International Criminal Court's lack of jurisdiction. In my paper, I explained that there is no sovereign Palestinian state, as the Palestinians do not fulfill the necessary criteria for statehood. Thus, there is no territory of a state over which the ICC can exercise territorial jurisdiction as required under the Rome Statute. Additionally, according to the court's mandate, jurisdiction is based upon sovereign states delegating to the court their own criminal jurisdiction over the territory and nationals. Since the Palestinian Authority does not possess, nor has it ever possessed, criminal jurisdiction over Area C, Jerusalem, and Israeli nationals, it cannot delegate such jurisdiction to the court. Therefore, the only possible legal conclusion is that the court lacks jurisdiction. That same day, I published my paper. The ICC prosecutor asked the judges to rule on the scope of the court's territorial jurisdiction in this situation. We expect that the court's decision will be based on solid legal reasoning in light of accepted international rules and norms, and reject the attempts to exploit the court for political ends. I wish to take this opportunity to thank you all for the essential work that you do. I consider the association a close partner in our work on these issues. I would like to conclude with a quote from one of the IJL's founders, René Cassin. Upon being informed of receiving the Nobel Peace Prize, he said, "It is not given to every man to have the luck to learn law, to teach it, to make it as a judge, and promote it internationally as an international judge. We are all lucky to have been presented with the opportunity to be able to promote the common good through the profession, and I am inspired that so many of you have chosen to use your legal training in order to advance human rights in Israel and abroad while combating anti-Semitism and xenophobia." Kassan added, "I would be happier if there were a little more justice in the world. I think we can all agree that this is a commendable goal, which the International Association has worked towards since its inception, and we should all inspire to promote a little more justice in the world. On this note, I wish you all an enriching and fruitful conversation. Thank you all."
Thank you very much, Attorney General. We will have more about the ICC and Israel after the break. in one of our presentations. And now it is my honor to invite Advocate Avi Chimi, the head of the Israel Bar Association, to address the Congress.
כבוד שרת התפוצות, חברת הכנסת עומר ינקלביץ', כבוד היועץ המשפטי לממשלה, דוקטור עורך הדין אביחי מנדלבליט, כבוד נשיא הארגון הבינלאומי של עורכי דין ומשפטנים יהודים, עורך הדין מאיר לינזן, כבוד סגנית נשיא הארגון הבינלאומי של עורכי דין ומשפטנים יהודים, אלוף משנה במיל, עורכת הדין פנינה שרביט ברוך, שופטים, שופטות ומשפטנים מכל העולם. מכובדיי כולם, שליחותו הציונית של הארגון הבינלאומי של עורכי דין ומשפטנים יהודים במערכת המשפט הבינלאומית הוכיחה מאז הקמתו ועד היום את חשיבותו הרבה. במהלך שנות קיומו ניהל וליווה הארגון מאבקים חסרי פשרות נגד תופעות אנטישמיות, הכחשת השואה והחרם על ישראל ברחבי העולם, וחבריו מהווים שגרירי אמת בהגנה על מעמדה המשפטי של מדינת ישראל בזירה הבינלאומית. לצערי, מאז פרוץ משבר נגיף הקורונה, התגברה תופעת האנטישמיות, ואנו עדים לעלייה במספר עלילות הדם המופצות נגד קהילות יהודיות ברחבי העולם. חורשי רעתנו מנצלים את התקופה הקשה שחווה העולם כדי להמשיך ולתקוף את העם היהודי ולייחס לו אשמה חסרת כל יסוד וביסוס להתפשטות הנגיף. אם לא די בכך, תקופה זו מלווה בעלייה חדה במספר התקיפות הפיזיות של יהודים במרחב הציבורי והתגברות האלימות המילולית ברשתות החברתיות המופנית כלפי יהודים. מציאות זו מחייבת את הארגון להרחיב את פעילותו גם לזירות אלה ולשמש כמליץ יושר של העם היהודי. כל זאת תוך שימוש בכלים המשפטיים העומדים לרשותו ובעזרת מיטב המוחות המשפטיים היהודים בישראל ובעולם כולו. כזכור, הארגון הבינלאומי של עורכי דין ומשפטנים יהודים הוקם ביוזמת חברים בהנהגת לשכת עורכי הדין מתוך הכרה בחשיבות שיתוף הפעולה ויצירת קשרים בין עורכי דין בישראל ועמיתיהם בחו"ל. מאז הקמת הארגון ובמשך כל השנים קיים קשר קבוע בין הארגון לבין לשכת עורכי הדין, כאשר מאז הקמתו שוכנים משרדיו בבית לשכת עורכי הדין בתל אביב. הלשכה בראשותי מחזקת את הארגון ובטוחה שימשיך בעשייתו המבורכת, הכוללת בין השאר שמירה על מעמדם המשפטי של מדינת ישראל ויהודי העולם. כולי תקווה שעשייה חשובה זו תמשיך ותסייע למדינת ישראל ויהודי העולם במאמציהם למיגור תופעות האנטישמיות ברחבי העולם. בברכת חברים, אבי חימי, ראש לשכת עורכי הדין.
Thank you, Advocate Chimi. I wanted to take this opportunity to commemorate one of the most impressive persons who the community of Jewish lawyers and jurists has lost this year, and I'm talking about the Honorable U.S. Supreme Court Justice Ruth Bader Ginsburg. The main mission of the IJL is to work together to advance human rights. This was also the lifelong mission of Justice Ginsburg. Therefore, it is not surprising that among the many awards that she received over the years, Justice Ginsburg was also awarded a Pursuit of Justice Award by IJL's American member organization. As a woman, I feel especially in debt to her relentless battle to advance women's rights and gender equality in the US, which has undoubtedly led to more gender equality and more women's rights all around the world, including in Israel. So thank you, RBG, and may you rest in peace. Just now we will have a break, and then we will have our main panel. And this year we don't have one main topic that all the panelists will address, but rather we have three presentations, each dealing with a different part of the mission of the IJL. Because what is the IJL about? For more than 50 years, Jewish lawyers and jurists from all over the world have been working together through the Ijl to advocate human rights everywhere and to combat anti-Semitism, racism, xenophobia, Holocaust denial, and the delegitimization of the State of Israel. So we have the good fortune to have three outstanding speakers who will each shed light on one of the aspects of this mission. The first speaker will refer to combating anti-Semitism, focusing on the US. The second will discuss the legal campaign against the State of Israel, focusing on the ICC, the International Criminal Court, and the case there concerning Israel. And the third will talk about the protection of human rights, focusing on Iran and maybe some other states. So this is going to be really interesting. Now, after each speaker's presentation, we will open the floor to Q's and A's, to questions and answers. But unfortunately, you will not be able to present your questions in person. What you should and are kindly invited to do is to post your questions in the chat during the presentation. I will read the questions, will collect them, and will raise them before the speakers to the best of my ability, taking into account time constraints. So I apologize in advance if I won't reach all the questions that will be raised. Please try to keep the questions short and clear. So now we will take a short break. We will resume at 5:40. You will see on the slide there will be a timer, so you can go now, have a cup of coffee, and be back 5:40 sharp to dive into the remarkably interesting presentations of our outstanding speakers. Don't miss it. Stay tuned. Thank you for rejoining us to the main part of the Congress. Our first keynote speaker, Mr. Ilan S. Carr, is the US Special Envoy to monitor and combat anti-Semitism. As Special Envoy, he advises the Secretary of State and is responsible for directing US policies and projects aimed at countering anti-Semitism throughout the world. Prior to his appointment, Special Envoy Carr served as a Deputy District Attorney for Los Angeles County, where he prosecuted violent crimes for more than a decade. Special Envoy Carr is an officer in the United States Army Reserve, and he has received multiple awards and commendations for his nearly 2 decades of military service. In 2003-2004, he deployed to Iraq in support of Operation Iraqi Freedom, where he led an anti-terrorism team in life-saving missions throughout the country and prosecuted terrorists who attacked US troops. He also assisted efforts to establish an independent Iraqi judiciary and trained Iraqi judges and lawyers on constitutional law and criminal defense. As the son of Iraqi Jewish refugees who fled persecution in Iraq, Special Envoy Carr speaks Hebrew and the Iraqi dialect of Arabic. And while in Iraq, and this is written in the official site of the State Department, while in Iraq, he met with remnants of the Jewish community there and led Jewish services in the former presidential palace of Saddam Hussein in Baghdad. Special Envoy Carr was the international president of the Jewish fraternity Alpha Epsilon Pi, served on the National Council of AIPAC, was a voting member of the Conference of Presidents of major American Jewish organizations, and a board member of Operation Gratitude. In the course of his work in the Jewish community, he has been a recognized leader in the fight against anti-Semitism on US college campuses and around the world. Mr. Carr will talk about America's fight against anti-Semitism. I remind you, please post your questions in the chat during his presentation. But first, we will see a short clip about the rise of anti-Semitism around the world.
Jews will not replace us!
After the coronavirus began to spread around the world, the blaming of Jews for the epidemic quickly followed. In the 21st century, social media carries the anti-Semitic message. This tweet said, "A lot of people are waking up to the fact that the coronavirus is a Jew organized crime created hoax intended to cover up Jew organized crime being carried out."
In recent months, there has been an uptick of hate on TikTok, including a Holocaust challenge that saw users dressing up and pretending to be Holocaust victims.
Police here in New York are increasing their presence in neighborhoods with large Jewish populations following a series of anti-Semitic attacks.
This morning, 5 people are wanted for assaulting 2 Jewish teens in Brooklyn. Police say the group smacked a 14-year-old in the head, then knocked his yarmulke off his head.
Surveillance video appears to capture another anti-Semitic attack in New York. It's the latest in a series of violent incidents targeting the Jewish community.
Well, thank you so much. Thank you, Pnina, Colonel, for that kind introduction. It's an honor to be with you. And thank you. Thank you to the International Association of Jewish Lawyers and Jurists for everything you do for our people and for our better world. Meir Lintzen, our president, thank you for your leadership and truly for the fight of our ages. I want to begin by apologizing a bit for my appearance. Usually dressed more formally, usually clean shaven. This week, sadly, we lost my stepfather, and today is the final day of Shiva, and that's why I'm a little bit less formal. But I do want to, as this is my first public appearance since our family's loss, I do want to dedicate this to my stepfather, Nissan Pardo, Nissan Ben Israel, a pilot in the Israeli Air Force, a proud, committed Jew who helped model for me the commitment not only to serving my country, but to fighting for the Jewish people. So this is dedicated to him. 2.5 weeks ago, my boss, Secretary Pompeo, stood at the podium next to Prime Minister Netanyahu and made an announcement. That announcement is that the United States of America will now regard the global BDS movement as anti-Semitic. We will identify organizations that engage in that anti-Semitic conduct, and that we will look to defund those organizations. This is one of a series of events that the United States has engaged in, and that the State Department has engaged in, to bring legal power to the fight against Jew hatred around the world. Months ago, the State Department announced the repudiation of the so-called Hansel memo, a Carter administration era memo regarding settlements in Judea and Samaria. And so now the State Department's policy, stated publicly, is that the United States will no longer regard settlements in Judea and Samaria as per se violations of international law. The State Department announced that the ICC will be sanctioned, and specifically any ICC prosecutor that targets American soldiers attempting to call Americans war criminals or Israelis. The Secretary of State was very clear that also Israeli soldiers, if the ICC plans to target the brave fighters of the IDF or the US Armed Forces as war criminals, they will be sanctioned. In fact, visas will be denied, and that has already happened. Meaning that if you're going to go after the soldiers of the IDF or the US Armed Forces, you're not going to be traveling to Disneyland. As you know, the United States left the UN Human Rights Council because of anti-Semitism in that body. And last December, in an historic, groundbreaking move, the President of the United States issued an executive order that applied Title VI civil rights protection to Jewish students on campuses throughout the United States. I was at the White House when he signed it, and he said very clearly, looked at the camera, he said, let me make this very clear. If you are a university and you are promoting the harassment and discrimination of your Jewish students, this is going to be very expensive for you. You're going to lose a lot of money. I gave these examples Because as you know so well, the fight against anti-Semitism, the fight globally against Jew hatred, is becoming increasingly a legal fight. And in the last 2 years, since my appointment as United States Special Envoy, I have worked very, very closely with organizations that bring that legal expertise to our fight. Great organizations like yours, but also like the Brandeis Center, like the Lawfare Project, like Shurat Hadin, or the legal team of Stand With Us. The list goes on. But more and more, we see that we absolutely got to use legal expertise and current law to fight Jew hatred. So now in this rise, as we saw in this video that you just showed, anti-Semitism has been rising all over the world. It's been rising internationally for over a decade now. It's been rising from the far right, the ethnic supremacists and neo-Nazis of the far right, who shoot at synagogues, hold despicable torch-lit rallies at night, reminiscent of an age from which we thought we had graduated long ago. These are the anti-Semites of vile internet chat rooms where open, unvarnished hate is trafficked in without constraint. But it's also been rising from the far left. This is the anti-Semitic camp that disguises its Jew hatred as political speech, as human rights talk. These are the Jew haters who talk about anti-Zionism and anti-Israel as their chief manifestation of anti-Semitism. It's been rising dramatically. We saw it in the former iteration of the UK Labour Party. We see it on college campuses, not only in the United States, but throughout the world. I meet with Jewish student leaders in Europe, and I hear the same things in Europe as I hear in the United States, which is that the price of safety on far too many university campuses is that a student divorce himself or herself completely from any connection to the land of Israel, any connection to Jewish peoplehood, to Jewish national self-determination. And of course, one can't mention the Z word, Zionism. One does so positively, that is, one mentions the word Zionism in any positive context only at their own peril. And anti-Semitism has been rising from militant Islam as well. This is the chief source of violence against Jews in Western Europe. It's the reason why, after a speech I gave on Shabbat at a Paris synagogue, I was told by a fellow congregant, remove your kippah. It's not safe to walk out in Paris with a kippah. By the way, I don't pass judgment about whether that's true or not, whether that's well-founded advice or not. That's beside the point, and one can debate that. But the fact that prominent Jews in the French Jewish community feel that way is evidence enough of the urgent challenges we face. Let me give you a sense of what our priorities have been over the last 2 years since my appointment as Special Envoy. Our lines of effort internationally against this rising global scourge of Jew hatred. First and foremost, physical safety. We work to ensure that every Jewish community is protected, because if one does not feel safe, if you can't leave your home and know that you're protected, or if you can't put your kids on a school bus or send them to school and know that they're safe, you cannot have quality of life. And so we work with our allies around the world to ensure that sufficient resources are devoted to protecting the Jewish community, ensuring physical safety. By the way, physical safety being the chief responsibility of any sovereign to its citizenry. Second of all, hate crimes. Pnina mentioned in the introduction that I'm a former prosecutor. Well, I've prosecuted hate crimes, and I know how important it is that law enforcement authorities make the statement through their action and through their criminal prosecutions that a violent crime committed with hate as a motive is worse and is more morally reprehensible than the same crime committed for a different motive. And so it is so important that hate crimes be vigorously investigated, appropriately prosecuted, and punished. I had the great privilege of working with law enforcement leaders from 7 separate German states who came together to talk about how best to investigate and prosecute hate crimes. This is so important. I've met with prosecutors around the world on this issue, and this is something really critically important to sending the message to the haters around the world regarding hate crimes. Third, the IRA definition of anti-Semitism. This is so deeply important because to confront a threat appropriately, one has to understand the threat. One has to define it. And we have a vehicle for doing that, and it's a very good vehicle. If a country hasn't adopted the IRA definition, my first ask diplomatically is that they do so. Thankfully, more and more countries have adopted the IRA definition. Argentina very recently, 2 Muslim majority countries adopted it, Kosovo by executive action, and by formal parliamentary action, Albania very recently adopted the IRA definition. Incredible developments. I'm proud to say that my team and I negotiated a memorandum of understanding with Bahrain to fight anti-Semitism together around the world. And that groundbreaking agreement adopts the IRA definition, the first Arab entity to use the IRA definition to define what anti-Semitism is. It's so important that every country does so, and that every local authority does so, including universities and police agencies and cities. And so that has been a key part of our work, and we're incredibly gratified by advancements in this area. After our MOU with Bahrain, the Global Imams Council, the largest NGO of Muslim faith leaders in the world, adopted the IRA definition of anti-Semitism. Again, game-changing. The internet is a key line of effort for us. Look, there's a reason why anti-Semitism has been rising for a decade now. It's driven by these powerful platforms that have given anti-Semites, and not just anti-Semites, but haters of all stripes, unprecedented global reach. They have trafficked in their ideology, spread it with unprecedented speed, recruited adherents with greater efficacy than we've ever seen. A recent European study found that the period of time required to radicalize a person to violence, actually to violent action, is a fraction of the time when performed online as compared with radicalization through traditional means, face-to-face interaction, rallies, and so forth. So there's the data. This has real effects. And so 2 months ago, we broadcast the first ever US government-sponsored conference focused on combating internet anti-Semitism, first of its kind, never before happened. And that's why this has been such a priority for us. If we can unlock this phenomenon of online hate, while at the same time, of course, embracing and championing our free speech values, we can elevate humanity, not only solve the problem of anti-Semitism, but truly fix so many things that are wrong with societies around the world. This is a key policy priority for us. And our conference, we hope, will be an important first step. And our last line of effort is this. These measures I've outlined so far are all inherently defensive. And that's appropriate. Anti-Semitism, of course, is an assault on the Jewish people, in fact, on civilization itself. And one has to defend against onslaughts of this kind. But as we all know, from military experience or from sports, you can't win a battle or a game if all you do is play defense. You also have to go on the offense. How does one go on the offense against anti-Semitism? So our last policy priority seeks to do just that. Going on the offense against anti-Semitism means driving a philo-Semitic narrative so that we celebrate and understand the deep and profound history of the Jewish people and the contributions of the Jewish people and of Judaism to civilization. Can one tell the story of, well, the United States or England or France or Germany or Russia, Poland, Hungary, without talking about the Jewish history of these countries? I'll give you an example. Germany, Now we're on the cusp of year 2021. In year 2021, Germany will commemorate 1,700 years of Jewish history in Germany. So I've had the privilege of working with our German interlocutors to ask the question, okay, what will this year be? What is the content of the message? What is the curriculum that will be driven to every kid in every classroom in every city in Germany, so that every single German child knows not only that it's 1,700 years, but knows a little bit about the content of those years. And that means not only Jewish influence and the influence of Jewish values on Germany, but the other way around. I asked the question, how many German kids know that the vernacular language of Ashkenazi Judaism from Russia to England is a form of German? The answer is not many. Now let's bring it to the United States. In the United States, we have a month endorsed by Congress and recognized by every single president of the United States for 40 years, called Jewish American Heritage Month. A period of time dedicated to celebrating, appreciating the Jewish people and Jewish heritage in America. You know what happens during that month? Not much. And so a lot of our focus has been to develop and craft. I'm proud to say we launched the Jewish Heritage Initiative, specifically to develop and craft a curriculum and public messaging to drive that content of the Jewish people, the Jewish story, Jewish history, and Jewish contributions to every city in these important countries. That's how you go on the offense against Jew hatred, by turning the tables and shouting from the rooftops what the Jewish people have meant to these countries and to civilization itself. Let me close with some good news, because let me tell you, there is a lot of good news in this fight of our times against this ancient and recurring, this tireless, insatiable plague of Jew hatred. We focus on the bad news as well. We should, because that's how you make the world a better place, but we cannot ignore the good news. Piece of good news number one is that we have remarkable allies and partners around the world who get it, who understand that the fight against anti-Semitism isn't only a fight for the safety of the Jewish people. It's a fight for civilization itself. These great leaders understand that they're fighting for the country or the continent or the world that their children will inherit. And these are great leaders at all levels. I've had the privilege to work with them over the last 2 years, from heads of government level to ministers to parliamentarians to appointed anti-Semitism coordinators, almost all of them not Jewish, who are not only allies in this fight, they are champions of this fight. And they are the reason why remarkable developments have happened. Curricula have been rewritten in countries. Every single Polish police officer is trained on hate crimes investigations. It's the reason why the IRA definition has been adopted by country after country. It's the reason why President Macron declared that BDS is unacceptable. It's the reason why the German Bundestag and the Austrian National Parliament passed measures officially branding BDS as anti-Semitism. It's the reason why, at a time of great peril in the United Kingdom, when the Jewish community said our future is being threatened by the hijacking of a major political party, it's the reason why that party lost in the election, and not only lost in exit polls, ordinary Brits said that anti-Semitism was one of the reasons they voted the way they voted. What a remarkable achievement that is. When rank and file citizens of a country say anti-Semitism is not the kind of future I want for my kids, that's a remarkable win. And there are so many more wins, and they're due to great people like Lords Eric Pickles and John Mann in the UK, or Frédéric Poitier in France, or Felix Klein in the UK, Katharina von Schnurbein in the EU, great leaders who are making a difference every single day in fighting Jew hatred. Piece of good news number two is that there is a state of Israel. The Jewish people do have national self-determination, and Israel's strength and excellence, a vibrant democracy, a beacon of human rights and tolerance, defended by a military excellent, known for its excellence throughout the world, yet committed to international humanitarian law, to the law of armed conflict. Now, Israel being a beacon of world-changing innovation, the success, the strength, the prominence, the excellence of the state of Israel makes the Jewish people stronger everywhere in the world and better able to combat anti-Semitism. A piece of good news number 3 is that despite rising anti-Semitism, the United States of America is still the most philo-Semitic country in the history of the world. And we are led by the most philo-Semitic administration we have ever had. From President Trump to Vice President Pence, to my boss, Secretary Pompeo, to Attorney General Barr, and so many others, we have never seen anything like this. We've combated anti-Semitism on the far right. We're the first administration to declare a violent white supremacist group as a terrorist organization. To combat anti-Semitism on the right, President Trump signed the Never Again Education Act, ensuring that future generations of American children will learn about the Holocaust and understand where vile right-wing anti-Semitism can lead. To combat anti-Semitism on the left, President Trump signed that executive order I spoke about earlier, protecting Jews on campus, saying basically enough is enough with the nonsense going on our college campuses. We send our children to be educated. How dare we allow them to be harassed and discriminated against? Not anymore, said President Trump. We've combated anti-Semitism from militant Islam, which focuses on the existence of the State of Israel, as does anti-Semitism from the left, by supporting the State of Israel like never before. Whether it's closing the PLO office in Washington, D.C., whether it's defunding UNRWA so that U.S. tax money no longer prints anti-Semitic textbooks, defunding the PA's Pay for Slay program so that U.S. tax money doesn't go to pay monthly stipends to killers, whether it's recognizing Jerusalem and moving our embassy there, recognizing Israeli sovereignty over the Golan Heights, declaring that settlements are not per se illegal under international law. Of course, unveiling a peace vision for Judea and Samaria that recognizes historic Jewish claims there, while at the same time paving the way for Palestinian sovereignty and Palestinian statehood. And then, of course, leading the world to a better place by negotiating groundbreaking, game-changing peace agreements between Israel and our Arab allies, the Abraham Accords, that have meant such a difference to the Middle East. You know, I was at the White House when the Abraham Accords was signed, and a senior member of one of the Arab delegations ran up to me and said, "Don't think this will be a cold peace. We will do great things together." And I tell you, I was choked up to see that kind of embrace, that kind of real affection for the Jewish people in the state of Israel is really a new world. And so this is what our administration has done. And I tell you, we've never seen anything like it. And so there's a lot of good news in the world. And as we fight anti-Semitism, we have to remember that. And I want to close by asking for your help. You've already been remarkable. But key issues remain that require legal-based organizations to draw those distinctions. So, for example, the distinction between condemning anti-Semitism and censoring it is an important distinction. Every time we try to condemn anti-Semitism, every time we try to pass the IRA definition, those who traffic in anti-Semitism will say, you're preventing us from you're censoring our speech. So we have to rely on lawyers to make the distinction between censorship and condemnation. And there are so many other areas where you have been so deeply helpful. And I know that you will continue to be deeply helpful. And I know as we work to fight this scourge, we can have no better partners than IJL as we work not only to banish Jew hatred, but truly to do tikkun olam b'malchut Shaddai, and build that better world that our children and grandchildren so richly deserve. And so I say to you, Chazak u'Baruch, may you go from strength to strength. And I look forward to seeing your great work for many years to come. Thank you for having me.
Thank you. Thank you so much for this impressive presentation and for the impressive work you've been doing. I think we have a lot of grounds for collaborative efforts, maybe also in the future. And I have quite a few questions, so I will try to maybe go through some of them. Maybe I'll ask 3 questions, and then you can answer, and then we'll see if we have time for some more. So the one I'll start with, because it links to the last sentence, last point you were talking about, is can legal action, this is by Sam Sager, can legal actions be taken against internet platform providers to stop anti-Semitic propaganda, especially taking into account how to do it without limiting freedom of speech? So that's one question. Another question, or there's a bunch of questions about the next administration, the Biden administration, and what is your evaluation, whether they will continue with the same line of efforts in combating anti-Semitism? What policies do you think they will maintain? What might change? And I will also ask another one about the, especially about also the BDS. Will the Biden administration, will they honor the current declaration with regard to BDS being anti-Semitic, and also with regard to Judea and Samaria? I'm looking for another more general question, and that is, do you think that anti-Semitism or combating anti-Semitism is more successful through political intervention, like legislative proclamation and diplomacy, or through legal action, court filings? So that's another question. We have some more questions, but let's start with these.
Great questions, all of them. So let me start with the first one. Why did I close my remarks in saying that we need organizations like you to draw these distinctions? Because these distinctions are ill understood. I gave one example of the difference between defining something as anti-Semitic and censoring it. Why should it be that so often when we try to pass the IRA definition, anti-Semitic groups will say, you can't do that, this is a violation of freedom of speech. What does this have anything to do with freedom of speech? One can condemn anti-Semitism while at the same time allow it, right? We had a Supreme Court case in the United States. Now, I realize, of course, that the United States is very different than Israel and Europe in terms of the breadth of our free speech protections. But let's talk about the United States, because that's an important part of the world, and a lot of speech comes from the United States, certainly on the internet. Supreme Court case that neo-Nazis had a right to march in Skokie, Illinois, famous case. Now, does that mean we can't condemn them as anti-Semites? Does that mean we can't call them what they are? It's a ridiculous idea to think that defining anti-Semitism as anti-Semitism has anything to do with limiting freedom of speech. Now, of course, the next question is, once you define something as anti-Semitic, what do you do about it? Well, there's a whole range of options. You can do nothing about it, you can condemn it, or you can imprison people for it. I'm not suggesting that would be illegal, but I'm just saying there's a whole range of options, but the response has nothing to do with the definition. And so we need, especially lawyers, not only policymakers, but we need legal organizations that are legal based, like yours, to draw these important distinctions. Now, moving to the internet, which was the first question, this is exactly what we're dealing with. So why did we do a conference 2 months ago? First ever US government-sponsored conference on addressing online hate. Why online hate? Hate is hate, right? Whether it's online, that's just a vehicle. Whether it's online or offline, it's the same basic thing, right? Yes, but online hate is so important and such a driver of the rise in anti-Semitism. And there's a basic question. What do you do about it? In the United States, where the First Amendment says even vile, despicable, poisonous speech is protected. What do you do when you have vile, despicable, poisonous speech that is poisoning the minds of a generation, that is luring, seducing people into these chat rooms where they're becoming radicalized? And online hate doesn't stay online. It moves offline into actual illegal activity. What do you do about it? That was the whole purpose of our conference. And I commend it, by the way. It's now on the State Department website. I commend it to all of you. It really is an important first step. And what we concluded is you can do a lot short of censorship. You can lobby advertisers to pull their ads and basically shut down all revenue from sites that are trafficking in anti-Semitism. Totally legal conduct. Why should we allow allow is the wrong word. Why should we not apply pressure to advertisers to pull their revenue dollars from anti-Semitic speech? You want to shut it down? You shut it down overnight by doing it. All kinds of other collaborations we saw could make a real difference. We also talked about measuring anti-Semitic speech on the internet because there's such a volume of it, and when you measure it and you look at the waves, the spikes and the troughs in the volume of anti-Semitism, you can actually predict what might happen offline and take steps to prevent it. So it's absolutely, we can do things in the realm of anti-Semitism online, and it's critical that we do so. Penina, you were going to say?
Yeah, because we have only 1 minute and a half left, so maybe
1 minute
just
and a half, I can answer all the other questions.
A short answer, especially about the next administration and what you think.
Related, I can answer all three questions in a minute.
So here you have.
A lot of the questions were about what the next administration will do. Yeah. Obviously, I can't speak for the next administration. And if in fact it's going to be a Biden administration, my hope would be that they continue on the same path. After all, these are not the measures I've outlined aren't about politics or party. They're about policy and good policy. The fight against anti-Semitism, the fight for the Jewish people, the fight for that better world that we want our children to inherit should be a bipartisan fight, a nonpartisan fight. And so I would hope, I pray, although I can't speak for anyone else, but I would pray that any president of the United States would want to contribute, would want to continue on this important effort. And I know that if we do, like I said, we could have no better partner than IJL, and I encourage you to continue your phenomenal work, which has made such a difference, not only for the Jewish people, but has made such a difference for the world. So thank you.
Thank you so much. And again, it's an opportunity to thank you for the work you've been doing, and a special thanks also for taking the time and joining us in this sad week, and our condolences also to you and your family.
Thank you. But Penina, on a happy note, let me take this opportunity to congratulate publicly my friend and colleague who is speaking next, Minister Erwin Kotler, on his appointment as Canada's international envoy on anti-Semitism. Erwin is a friend, and Canada could not have made a better choice. This is a win for Canada, and it's a win for the world. And so Mazal Tov to my friend Erwin Kotler. I know he is going to do a fantastic job.
Yes, thank you. And I think he's already hearing you, and we will see to it later when we talk to him. Thank you again.
Thank you.
So now we turn to our second speaker, who is Deputy Attorney General for International Law in Israel, Dr. Roy Schoendorf. Dr. Schoendorf serves in this position since October 2013, and in this capacity he provides legal counsel to Israel's government on all aspects of public international law, including its interpretation and application within Israel's legal system, as well as with respect to international litigation, various aspects of treaty negotiations, and representation of the State of Israel in international forums. Prior to his appointment as Deputy Attorney General, Dr. Schoendorf was the Director of the Department of Special International Affairs within the State Attorney's Office. And before joining the Ministry of Justice, he worked with the International Dispute Resolutions Group at Debevoise & Plimpton law firm. He has also served as a legal advisor to Israeli delegations for peace negotiations with Syria, Lebanon, Jordan, and the Palestinians. So we have a shared history there. And was a member of Israel's delegation in the negotiations for the establishment of the International Criminal Court. He earned a doctorate of juridical science from New York University, School of Law, NYU School of Law, and holds degrees in law and economics from Tel Aviv University. Dr. Schondorf, who I must call Roy, because we're good friends and we have shared history. So Roy will talk about Israel and the International Criminal Court. Again, his presentation will be followed by a Q&A session, so please post your questions on the chat. We had many questions for Ambassador Carr, and I hope there will be many interesting questions for Roy too. We will first see a short clip with an overview of the International Criminal Court, the ICC.
The International Criminal Court is the first permanent court with jurisdiction over the most serious crimes threatening the peace, security, and well-being of the world. In 1998, during the Rome Diplomatic Conference on the International Criminal Court, 160 countries negotiated a treaty to design the world's first permanent International Criminal Court. On the 17th of July 1998, 120 nations voted in favor, and on July the 1st, 2002, the Rome Statute entered into force after ratification by 60 countries. The court is located in The Hague, the Netherlands.
The court may exercise jurisdiction only if they were committed on the territory of a state party or by one of its nationals. These conditions do not apply if a situation is referred to the prosecutor by the United Nations Security Council or in a situation in which a state makes a declaration accepting the jurisdiction of the court.
The court is intended to complement, not to replace, national criminal justice systems. It can prosecute cases only if national justice systems do not carry out proceedings or when they claim to do so, but in reality are unwilling or unable to genuinely carry out such proceedings. This fundamental principle is known as the principle of complementarity.
Good evening. I would like to thank the International Association of Jewish Lawyers and Jurists for inviting me to speak today in this conference. It is a pleasure to meet you all virtually. I hope you all stay safe and healthy and that things will go back to normal soon. Today, I would like to speak about the past year's developments at the International Criminal Court regarding the so-called situation in Palestine. As many of you know, the ICC was established to address mass atrocities that deeply shock the conscience of humanity. Israel supported and still supports this noble mission. However, regrettably, the court is far from reaching this goal. Throughout the 18 years that it has operated, the ICC has secured relatively few convictions. It has also spent a great deal of energy on attempts to adopt controversial interpretations which were disconnected from the original intention of the drafters of the statute. Thusly, the court effectively neutralized its own screening mechanisms, invested resources into cases which were clearly outside its mandate, and has rendered itself vulnerable to political interests. The treatment of the ICC prosecutor of the Palestinian effort to embroil the ICC in the complex and politically charged Israeli-Palestinian conflict is a recent example of the problems I just described. On 20 December 2019, the ICC prosecutor announced that she has concluded her 5-year preliminary examination into what she calls the situation in Palestine. The prosecutor did so with a determination that all legal criteria for the opening of an investigation have been met. However, The prosecutor recognized the uncertainty of her conclusion with regard to the unique and highly contested legal and factual issues attaching to this situation. Accordingly, she asked the judges to give her the green light to open an investigation. She requested, in the form of a request for a judicial ruling, that the judges would confirm her position that the scope of the territorial jurisdiction in this situation comprises of the West Bank, East Jerusalem, and the Gaza Strip. This is a highly unusual practice. The prosecutor's request is still pending before the judges of the pre-trial chamber. Israel's position with respect to the jurisdiction of the court in this matter is very clear. Israel is not a state party to the Rome Statute, the Palestinian Authority is not a state, and the ICC simply has no jurisdiction. A few hours prior to the prosecutor's announcement, the Israeli Attorney General published a memorandum on the ICC's lack of jurisdiction over the so-called situation in Palestine. The Ministry of Foreign Affairs also published a synopsis which includes a brief overview of the main legal arguments and also adds some important policy considerations. This legal position was the product of hard work and cooperation between my office, the legal department of the Ministry of Foreign Affairs, and the legal department of the National Security Council. The Attorney General's memorandum explains in detail that there is no sovereign Palestinian state, as the Palestinians do not fulfill the necessary criteria for statehood. Thus, there is no territory of a state over which the ICC can exercise territorial jurisdiction as required under the Rome Statute. It should be emphasized that according to the court's mandate, jurisdiction is based upon sovereign states delegating to the court their own criminal jurisdiction over their territory and nationals. In that regard, the Palestinian Authority does not possess, nor has it ever possessed, criminal jurisdiction, neither de jure nor de facto, over Area C, Jerusalem, and Israeli nationals, and thus cannot delegate such jurisdiction to the court. It is also important to emphasize that the alleged recognition of Palestine by some states cannot compensate for the absence of the established criteria for statehood, and that the Palestinians' claim to self-determination must not be conflated with any claim to statehood. Events surrounding the Palestinians' purported accession to the Rome Statute did not settle any of these jurisdictional questions. A serious legal analysis can only lead to one possible conclusion. The ICC has no jurisdiction over this situation. Reaching a different conclusion would require adopting creative interpretation of the factual and legal record, deviating from the accepted approaches in international law in favor of fringe theories on fundamental issues. A few weeks after the prosecutor submitted her request, the pretrial chamber invited states, organizations, and individuals to submit their observations on the scope of the court's territorial jurisdiction, subject to the chamber's leave. Following this invitation, 23 observations supporting the position that the court lacks jurisdiction were submitted. These include 7 states that submitted their own observations: Germany, Australia, Brazil, Hungary, Uganda, Austria, and the Czech Republic. Germany, a state party to the Rome Statute, holds in its submission that the technical act of circulating an instrument of accession cannot determine the status of an entity as a state, and that statehood under international law or lack thereof requires an evaluation by the court. In addition, the submissions made to the court also included observations by several organizations and many well-known international law experts. Among the many experts supporting this position were Professor Robert Badinter, former Minister of Justice of France, Professor Erwin Kotler, former Minister of Justice and the Attorney General of Canada, Professor David Crane, former Chief Prosecutor of the Special Court of Sierra Leone, Professor Guglielmo Verderame, a professor of international law, and the well-known Professor Eyal Ben-Benisti, and Professor Malcolm Shaw. In fact, Professor Shaw's submission is of particular importance in view of the prosecutor's extensive reliance on his work in her submission in order to support her theory regarding Palestinian statehood. Professor Shaw clarified that in his view, the prosecutor's analysis is flawed according to international law. Another significant position that focused on the prosecutor's inaccuracy in her treatment of the Oslo process was submitted by Ambassador Dennis Ross. As it is well known, Ambassador Ross is perhaps one of the most experienced diplomats on the Israeli-Palestinian negotiations. In his submission, he clarified that under the Oslo Accords, the Palestinian Authority does not have and has never had any type of criminal jurisdiction, and that the issue of statehood was effectively reserved for future negotiations. The International Association of Jewish Lawyers and Jurists submitted its observations as well. The association, among other claims, emphasized that jurisdiction is a question of law and that it requires to establish a standard of certainty. This is especially important as the prosecutor admitted that Palestinian statehood has not been definitely resolved. The association also claimed in its submission that, and I quote, the OTP's argument suggests a result-oriented process reasoning backwards from a desired outcome, end of quote. Unfortunately, even after reading the well-founded opinions that were submitted, the prosecutor, in her response to the pre-trial chamber in April 2020, chose to adjust her arguments rather than admitting that her legal approach is shaky. It is quite puzzling that even after 5 years of preliminary examination, the prosecutor is still jumping through hoops to provide legal reasoning to the jurisdiction she claims to have. The prosecutor's primary position in her submission from December 2019 was that the term state in the Rome Statute should be determined by the Palestinians' entity's status as a state party, and that once the Palestinians submitted their instrument of accession, and I quote, no additional consent or separate assessment is needed, end quote. In her response to the submissions made to the court, she referred, among others, to the submission of the association and essentially admitted that, I quote, statehood is a condition precedent for accession to the statute, end quote. However, she claimed the state parties bear the ultimate responsibility for ensuring that only states that are qualified to do so exceed, and once an entity is permitted to exceed, the organs of the court, including the chamber and the prosecutor itself, are required to accept its status as a state party. These inconsistencies and result-oriented process are also reflected in the prosecutor's alternative position in her request. The prosecutor claimed that the Palestinian entity may be considered a state for the purpose of the Rome Statute under general international law. Just 2 weeks before submitting her original request, the prosecutor expressed regarding another situation under preliminary examination, the South China Sea situation, the position that territory, and I quote, includes those areas under the sovereignty of the state, and interpreted sovereign territory to mean, quote again, the areas over which a state exercises exclusive and complete authority. However, in our case, the prosecutor ignored this legal reasoning and instead chose to rely on alternative arguments based on non-binding resolutions of political organs and the right to self-determination. A few months later, in April 2020, she claimed that sovereignty resides with the Palestinian people. I will not elaborate further on the tortuous path the prosecutor took in her arguments today. I will only mention briefly one additional point in this context. While the prosecutor does not accept sovereignty over the territories in abeyance, she fails to provide a convincing legal reasoning for her dissent. Instead, she chooses overly complicated legal arguments for a conclusion that should have been simpler. Jurisdiction is not a legal technicality. It is a substantive requirement, and it should be treated accordingly and be evaluated carefully. This is especially important for a criminal institution. After 5 years of preliminary examination, the prosecutor submitted altogether over 170 pages of arguments to make the case of jurisdiction and to tailor case-specific interpretations to our situation. That, instead of rejecting the attempts to exploit the court for political ends. Beyond the legal issue of jurisdiction, it should be reminded that the court should focus on the greatest crimes of concern to the international community as a whole, and that the ICC is a court of last resort that is complementary to national judicial systems. Israel is a law-abiding democracy. To the extent that there are credible allegations against Israeli nationals, the Israeli legal system is more than willing and able to address them. We expect the pre-trial chamber's decision on this issue to be based on a solid legal foundation of international law and on the court's mandate. Adopting the prosecutor's position would harm the ICC's legitimacy and steer it even further away from its original mission and mandate. Finally, the prosecutor's intervention concerns matters that lie at the very heart of the Israeli-Palestinian conflict, interfering with any prospects of future agreements that may come. The court was never meant to replace complex political processes. This is evident in our situation, and especially with regard to the Oslo Accords. These accords are the framework to the parties' relations, and great caution is required to preserve them. We saw in June that when the pre-trial chamber asked the Palestinians to submit additional information on the accords, pursuant to Abu Mazen's declaration that referred to their validity, the Palestinians were cautious enough to avoid declaring the accords to be void. The prosecutor's treatment of the accords in her submissions, including the completely unfounded insinuation that the Palestinians were coerced into the accords, demonstrate the damage that the court's intervention can have on the delicate Middle East peace process. Just recently, historical agreements were reached between Israel and the United Arab Emirates and between Israel and the Kingdom of Bahrain. This is an important reminder that negotiations and agreements between parties are the only way to resolve political disputes. The court's intervention will only make it harder. The last few weeks have allowed us to be optimistic and reminded us to trust the power of negotiations. I hope that I will be able to spend my time working on these positive processes in the Middle East and not on ill-founded proceedings in the court. A decision to reject the Palestinian effort to embroil the court in the Israeli-Palestinian conflict would not only be beneficial to the future of the Middle East, but also to the court, which I hope will remain faithful to and operate within its original mandate. Thank you very much.
Hi, Roy. Thank you for your presentation. It was very interesting and raised a lot of questions, although I must say that we don't have many questions in the chat. So I'll ask you the question that we did get, and then I have some questions of my own, and they will be tough, so embrace yourself. So the question that we do have is there a process to challenge the impartiality of Ms. Bensouda and to bring about her dismissal from her position for bringing the ICC into disrepute? Yes.
Well, I think the court, of course, has various mechanisms that of oversight, both over the prosecutor and also over the conduct of other parts of the court. But I think this, in some way, misses the fundamental issue that is at stake here, which is which direction the International Criminal Court intends to take. And I think this is an issue that goes far beyond just the Israeli-Palestinian conflict. It's an issue that goes to the heart of the basic mission of the court. The court, as it was originally conceived, was supposed to be a court that deals with the most severe and serious crimes under international law, mass atrocities, things that are similar perhaps to what we have witnessed in during the Holocaust or during events in Rwanda or the former Yugoslavia, maybe things that are similar to what the world has seen recently in Syria. It was not supposed to be the police of the world. And in some ways, the court, throughout its 20 years of existence, has consistently, and most notably the office of the prosecutor, but also the judges in some of their decisions, eroded many of the fundamental guarantees that were put in the Rome Statute in a way that extended the jurisdiction of the court and diluted those mechanisms that were supposed to help the court focus on its main mission and not go in a way that is too broad and which brings into areas which are more political or controversial. And I think the key issue for the court, also in the Israeli-Palestinian case, is whether the court is going to continue with this approach that has received significant criticism, most notably recently from Judge Richard Goldstone, that many of you would remember, that in a report criticizing the court, a report that was actually asked for by the Assembly of State Parties, expressed very harsh criticism of the office of the prosecutor and the court exactly for these things. And many countries around the world share the same concern and the same view. And it's really that question that now lies before the pre-trial chamber, whether to adopt expansive, non-conventional interpretations in order to acquire jurisdiction, or whether to take a more mainstream, solid, responsible approach that is more consistent with the original mandate of the court. And I think we should focus our energy in arguing exactly that.
Just to follow up on, you mentioned the report. It's independent expert review, and it is going to be brought before the Assembly of State Parties this month. Do you think, what are the chances that they adopt the recommendations of the report? And if they do, will it impact the pre-trial chamber's decision, or is it, since it's focused, or how would that play? Do you think they would raise, for example, the gravity, the conditions for gravity as is recommended in the report, if it is indeed adopted by the state parties?
I mean, first of all, it is always very difficult to speculate on what a panel of three judges will do. I certainly think that the judges, not just the three judges that sit in the free trial chamber that is tasked with the Israeli-Palestinian situation, but also generally the judges of the court and the prosecutor should take very seriously the report of Justice Goldstone and the entire expert panel. There is a very significant part of the international community, including some of the leading supporters of the court, that feel that the court needs an urgent change. A lot will depend also on the identity of the next prosecutor. The prosecutor, there are currently elections going on for the position of the next prosecutor of the court. And of course, the identity of the prosecutor could impact the policies of the court. And a lot depends on the approach that state parties will take in the coming Assembly of State Parties. But even if there is even if state parties cannot reach a consensus on particular steps, I think the overall sentiment that the state parties project towards the court certainly calls the court to seriously consider changes to its approach. And I certainly think that the question that currently lies before the pre-trial chamber with respect to the Israeli-Palestinian conflict is an excellent opportunity for the court to demonstrate a more responsible approach rather than the overreach that has perhaps that was demonstrated so far in its jurisprudence.
I have here a question of Jonathan Turner. What will happen if the pre-trial chamber decides that the ruling on jurisdiction is premature before any defendants have been identified or charged? This was the position of the defense of the court, the official department there. So do you think, what if they do adopt this position, how would it impact the continuation of an investigation or the opening of an investigation?
Well, again, it's very hard to speculate on what specific officials of the court will do. I can say that, at least from my perspective, I would expect the prosecutor to have investigations, certainly at the ICC, with a very solid basis for jurisdiction. I think that the prosecutor herself, in approaching the pre-trial chamber in this very unconventional procedural step, demonstrated that she herself does not feel completely convinced that the court has jurisdiction, because if it was so easy and clear-cut, I guess she would have just decided the matter. And I think that if the court declines to provide an answer, in my view, the prosecutor should then take the cue and close the case. I don't think that the court should proceed on the basis of very debatable jurisdictional claims. In my view, which I think is fairly detailed in the Attorney General's memorandum, claims that are that have a very weak legal foundation.
There is a question here about why isn't Jordan brought into the case, since the territory was controlled by Jordan. I will ask maybe a little bit a different question. You could answer that, but what about the Palestinians? Do you think they will also, if there is an investigation, how will it impact them, the Palestinian Authority and the Hamas?
I think, in my view, the prospect of an investigation is not good for all of us here in the Middle East. First of all, I think it must be quite clear that if there is an investigation, the real war criminals should be investigated, and this includes, of course, Hamas and the Palestinian Authority. I think that various complaints have been brought to the court with respect to officials of both Hamas and the Palestinian Authority. But I think that from the perspective of our efforts to achieve reconciliation and peace in the region, I think that a narrative in which both sides begin to blame each other in war crimes and try to do that with proof in an international criminal court only gets the more extreme people more powerful, only gets the more extreme narratives to be heard and have the focus and instead of actually promoting peace and resolution. And I think in that sense, it's not good for anyone in the region to get ourselves into that type of a conversation. I think that a situation where we find where the court tries to take jurisdiction will necessarily make it impossible to have any progress in the peace negotiations, and that I would say is really unfortunate, especially as we currently experience a period of greater optimism in the Middle East with the peace treaties that we have just signed with the United Arab Emirates and the Kingdom of Bahrain, and the progress we've made with Sudan, and with the Palestinians coming back now to reestablishing the security cooperation. All of these suggest that there is a better prospect in negotiations than actually in derailing the process between people through unfounded accusations of criminality.
Thank you very much, Roy. That was very interesting, and our time is up, but I'm sure we will discuss the ICC again in future conferences. So thank you again for joining us.
Thank you very much. It's really a pleasure to participate in this important and exciting event. Thank you.
We now turn to our third and final speaker in this part of the Congress, the Honorable Irwin Cotler. Professor Cotler has just been appointed, as was mentioned before, has just been appointed by Canadian Prime Minister Justin Trudeau to the role of Special Envoy on preserving Holocaust remembrance and combating anti-Semitism. Professor Cotler is the founder, chair of the Raoul Wallenberg Center for Human Rights, an Emeritus Professor of Law at McGill University, former Minister of Justice and Attorney General of Canada, and longtime Member of Parliament, and an international human rights lawyer. A constitutional and comparative law scholar, he is the author of numerous publications and seminal legal articles, and has written upon and intervened in landmark Charter of Rights cases in the areas of free speech, freedom of religion, minority rights, and war crimes justice. In his roles as Minister of Justice and Attorney General, and as a leading parliamentarian on the global stage, Professor Kotler has always put an emphasis on the protection of human rights, on gender and minority equality, on confronting racism and hate, and on the pursuit of international justice. As an international human rights lawyer, he has served as counsel to prisoners of conscience and political dissidents. A feature article of him in Canada's national magazine, Maclean's, referred to him as counsel for the oppressed, while the Oslo Freedom Forum characterized him as freedom's counsel. He is the recipient of many honorary doctorates and awards for his work and for his tireless efforts to promote and protect human rights and ensure peace and justice for all. Professor Kotler's presentation is titled "The Global Political Pandemic, Assault on Human Rights, and the Pandemic of Impunity." I again remind you to post questions in the chat for our Q&A session that will follow the presentation.
I'm delighted to participate in this conference. Indeed, I have the best of memories of having been present at the founding conference over 50 years ago and having been engaged with the IJL ever since. We meet at an important historical inflection moment, not only on the occasion of a global COVID pandemic, but a global political pandemic, characterized by a resurgent global authoritarianism, the backsliding of democracies, the assault on human rights, and political prisoners as a looking glass, the whole underpinned by yet another pandemic, the pandemic of impunity. Accordingly, I would like to share with you 4 case studies of this political pandemic and the pandemic of impunity and the human rights advocacy that can address and redress it, that can help secure justice for the victims and accountability for the human rights violators, and where the IJL can also play an important role in this effort. The first case study is that of Xi Jinping's China, and I use that term to distinguish it from the people of China who are otherwise the targets of Xi Jinping's massive domestic oppression, which represents today the most serious assault on the rules-based international legal order, and which includes the targeting, and increasingly under the cover of the pandemic, the targeting of what Xi Jinping has called the 5 poisons, the mass atrocities against the Uyghurs, the political persecution and prosecution of the Falun Gong, the assaults not only on the democracy movement in Hong Kong, but on democracy itself, the repression of Tibetans and the threatening of the Taiwanese. And there is more. What is not so well known is that China jails more journalists than any other country in the world, jails lawyers and human rights defenders. And it was this suppression of information, this jailing of dissidents and doctors, of lawyers and human rights defenders, which precipitated the spread of the coronavirus, and also the increasing global disinformation campaign and penetration campaign, which the Canadian National Intelligence Parliamentary Committee said constituted a threat not only to the national security of Canada in terms of Xi Jinping's penetration into Canada, but indeed a threat to our democracy. But it is the mass atrocity against the Uyghurs, acts that the Foreign Affairs Committee of the Canadian Parliament said recently were acts constitutive of genocide, that represents the most serious and threatening assault on the rules-based international order. I testified before the Canadian Foreign Affairs Committee this past July, wherein I myself brought forth evidence that the mass atrocities were acts constitutive of genocide. But just before I was to testify, I witnessed evocative and chilling images of Uyghurs blindfolded, heads shaven, shackled, boarded on trains to the concentration camps. I make no analogies to the Holocaust, not even in the acts constitutive of genocide. But one could not ignore these evocative, chilling images. And I then shared with the Foreign Affairs Subcommittee the evidence that these mass atrocities were acts constitutive of genocide, which included the mass incarceration of over 1 million Uyghurs in concentration camps, enslaved, tortured, abused, raped, and murdered. The mass sterilization of Uyghur women as one of many coercive population control techniques that have drastically reduced the population of the Uyghurs. The forced separation of Uyghur children from their families. The massive assaults on the Uyghur religion, culture, identity, language, and which has included also the destruction of thousands of mosques and state-sanctioned incitement to hate and genocide at the Uyghurs, characterizing them as a cancer and worse. All of this, as I said, not only constitutive of acts of genocide, but which recalled for me and which were in my mind's eye as I spoke, the warnings of Nobel Peace Laureate and Holocaust survivor Elie Wiesel, who warned us of the danger of silence in the face of evil, of the danger of indifference and inaction in the face of mass atrocity and genocide. Whereas he put it, indifference always means coming down on the side of the victimizer, never on the side of the victim. And as we have witnessed that the Holocaust and the genocide that follows not only have been engaged in unspeakable horrors, but what makes these horrors so unspeakable is that they were preventable. Nobody can say, for example, with regard to the genocide of the Tutsis in Rwanda, where 10,000 Tutsis were murdered every day for 3 months. Nobody could say we did not know. We knew, but we did not act. Just as with regard to the genocide in Darfur, we knew, but we did not act. And now with regard to the Uyghurs, we now know, and we are still not acting. The second case study is Khamenei's Iran. 2 years ago, the Raoul Wallenberg Center for Human Rights, which I chair, produced a report called Realizing Rights Over Repression in Iran, documenting and detailing the assault by the Iranian regime on the leaders of all civil society groups in Iran. Assaults on women, on journalists, on environmentalists, on lawyers, on trade unionists, on religious and ethnic minorities, on students, on peace protesters, on dual nationals, and the like, reflecting, in effect, a widespread and systematic assault and amounting to the criminalization of innocence, the criminalization of fundamental freedoms. Nasrin Sotoudeh, who you saw on the video, is the iconic Iranian woman human rights lawyer who embodies the struggle for human rights in Iran and whose persecution and prosecution is a looking glass into the assault on human rights in Iran. Nasrin Sotoudeh has gone down the line ever since and before and since her first imprisonment 10 years ago. And I've been acting as her international legal counsel for the last 10 years, where she has been repeatedly arrested for doing nothing other than going down the line for the rights of women, for the rights of juveniles destined for execution, for the rights of journalists whose expression is silenced, for the rights of minorities like the Baha'i targeted for persecution, for lawyers imprisoned for defending political prisoners, and on behalf of other political prisoners, until she became, some 2.5 years ago, yet again a political prisoner herself, and sentenced just a little over 2 years ago to 38 years in prison and 148 lashes, a virtual death sentence for a woman in her late 50s. In August, some 3.5 months ago, she launched a hunger strike, not on her own behalf, but on behalf of other political prisoners at risk of catching COVID in the Iranian prisons. Suffering from heart complications and respiratory disease, she was transferred from Evian prison to a hospital for medical treatment. But she was denied the treatment at the hospital, abused and detained at the hospital, and returned to prison, a decision that the UN special experts collectively called unfathomable. While in Evian prison, while engaging in our advocacy, we enjoyed the support of Prime Minister Trudeau of Canada, who condemned her imprisonment and called for her release, as did President Macron of France, as did then President and presidential candidate Joseph Biden, now President-elect, as did the European Union. But she was transferred not only from Evian prison to medical treatment, which they assured her she would then get, but to another prison, Korchak prison, which is characterized as the end of the world, being a vermin-infested prison. Resulting from sustained advocacy, a month ago, she was released on furlough, but just 2 days ago, returned again to prison. And so we conveyed an open letter to the Iranian leadership, a letter signed by the International Bar Association, by USA PEN, by the Center for Human Rights in Iran, and by the Raoul Wallenberg Center for Human Rights in Canada, which I chair, calling not only for the quashing of her conviction and her release, but saying that every day of her continuing imprisonment is an assault on the Iranian Islamic Constitution, on Iran's international treaty obligations, and that only her release would demonstrate Iranian fidelity to the rule of law, to her own law, and to Iran's own international treaty obligations. The third case study is Maduro's Venezuela. Some 4 years ago, I was appointed as a member of a panel of independent legal experts, as it was characterized by the Organization of American States, to look into whether there are reasonable grounds to believe that crimes against humanity are being committed in Venezuela. In May 2018, after comprehensive inquiry, after analyzing all the documentary evidence and witness testimony, we concluded that there are reasonable grounds to believe that 7 major crimes against humanity were being committed in Venezuela, including multiple murders and extrajudicial executions, some 12,000 cases of arbitrary detention and deprivation of liberty, some of the worst evidence of torture that we have ever seen, disappearances, political persecutions, sexual violence and rape in detention and without, and perhaps the worst of the crimes against humanity, state-orchestrated humanitarian suffering, the weaponization of food and medicine, targeting their withdrawal from those in the opposition or those believed to be in the opposition. In the course of our investigation, we held public hearings in Washington, and the evidence with respect to the assaults on the rule of law and the independence of the judiciary and the democratic opposition was astounding. Let me just give you one case study. I had been representing the leader of the Democratic opposition, Leopoldo Lopez, who had been imprisoned himself on trumped-up charges. But what we heard in the testimony before us was both compelling, revealing, and in fact indicting of the Maduro regime expressly and specifically. We heard from Judge Renata Tovar, who had escaped from Venezuela, who appeared before our hearings in Washington and testified that she was ordered to issue a false arrest warrant against Leopoldo Lopez, lest she end up with what was characterized to her by the Maduro regime as the Afuni effect, referring to the imprisonment and torture of Venezuelan judge Maria Lourdes Afuni for doing nothing other than acquitting a political prisoner, as a result of which she, Judge Afuni, 10 years ago, was arrested, imprisoned, tortured, in detention, and has been languishing ever since. And indeed, recently was convicted to yet another 5 years under the false and invented charge of spiritual corruption. I've also been acting on behalf of Judge Afuni because the Afuni effect is used and has been used to intimidate other judges, as I mentioned, with regard to Judge Renata Tovar. We also heard from the special prosecutor in Lopez's case, Franklin Neves, who also had escaped from Venezuela, who came before our inquiry and testified that he was ordered to issue false and trumped-up charges against Leopoldo Lopez. And we heard from witnesses who said that they were tortured into false confessions against Leopoldo Lopez. The whole demonstrating the massive assault on the rule of law, the independence of the judiciary, and the democratic opposition in Venezuela. 6 months after we tendered our report, the Foreign Minister of Canada at the time, Chrystia Freeland, led 7 nations in making the first ever collective referral of a state party to the ICC, namely Venezuela, to the International Criminal Court. But to date, Venezuela has yet to open an investigation into the crimes against humanity in Venezuela, notwithstanding the fact that the UN Commission on Human Rights issued its own fact-finding report 6 months ago that corroborated our report, Crimes Against Humanity in Venezuela. And just days ago, the Organization of American States, through its newly appointed special rapporteur on the responsibility to protect, Jared Genzer, also a senior fellow at our Raoul Wallenberg Center for Human Rights, issued a report that not only corroborated our OAS report and the UN Commission on Human Rights report of crimes against humanity in Venezuela, but in fact unmasked the special prosecutors in action in not opening an investigation. The whole to be contrasted, and you just heard from Roy Schondorf, with the case of the ICC opening up an investigation into the special prosecutor, into the situation in Palestine, even though Israel unlike Venezuela, is not a state party to the ICC, even though Palestine is not yet a state and does not even constitute the attributes yet, though I've supported Palestinian self-determination and right to independent statehood, but is not yet a state and does not yet have the attributes for statehood under international law. And where other principles of complementarity and the gravity of the offense and those discussed so eminently by Roy Jordan should preclude any jurisdiction by the ICC in this case. So the ICC does not take jurisdiction in a case where the evidence is so compelling of crimes against humanity as in Venezuela, and does not open an investigation there, but does do so in the case of the situation of Palestine with regard to Israel, which in effect impugns, for the reasons I mentioned, the independence, impartiality, and integrity of the ICC. And I say this not only as someone who's been a long-time supporter of the ICC, but who, as a parliamentarian, convened the first ever Parliamentary Consultative Assembly for an International Criminal Court in 2002, who tabled legislation adopted by the Canadian Parliament, domesticating the Rome Statute in Canadian legislation and authorizing a universal jurisdiction, who's been supportive of the ICC as a successor international tribunal of final adjudication to Nuremberg, not a tribunal of original jurisdiction, let that be clear, but who has been consistently disappointed of late in what appears to be dual standards as exemplified in the Venezuelan and situation of Palestine assumption or non-assumption of jurisdiction by the court. The fourth and final case study is that of Mohammed bin Salman's Saudi Arabia, and is
Professor
the
Kotler,
case
if you could
of the imprisoned Saudi blogger Raif Badawi. Badawi was imprisoned 8 years ago for saying then what the Crown Prince Mohammed bin Salman has been saying himself for the last 3 years, namely calling for a more open Saudi Arabia, a more moderate Islam. But not only has he been imprisoned and is now in his 8th year of imprisonment, as you saw in the video, but so has his sister Samar Badawi for doing nothing other than calling for the right to drive, a reform that in fact was implemented by the Crown Prince himself. 2.5 years ago, the then Foreign Minister Chrystia Freeland tweeted a call for the release of the two Badawis. The Saudi authorities erupted in fury, ejecting the Canadian ambassador from Saudi Arabia, recalling the Saudi ambassador to Canada, suspending all trade and investment with Canada, recalling 15,000 Saudi students from Canada, in effect a self-inflicted wound. But the reason I'm sharing this with you is that not one democracy came to Canada's defense. And 2 months later, Mohammed bin Salman, feeling enabled, this took us down the road to the brutal assassination of Saudi journalist Jamal Khashoggi in the consulate in Istanbul. That brutal assassination for a period did sound the alarm, and there was the mobilization of concern with respect to what is happening in Saudi Arabia. But that soon abated, and we saw, as part of the culture of impunity, Saudi Arabia being rewarded with being chair of the G20, which held its meetings just weeks ago, where no mention was made of either the imprisoned women human rights defenders, nor of the case and cause of Raif Badawi. And I would like to think that maybe Israel has a role that it can play here in that, given the recent meetings between Netanyahu and MBS, given the fact that President-elect Biden has said that there will be a change in U.S. policy towards Saudi Arabia in terms of accountability and the like, Israel, through quiet diplomacy, might recommend to MBS that it would be in his self-interest, in the interest of Saudi Arabia's relationships with the incoming Biden administration, to free the 5 imprisoned women human rights defenders and to free Raif Badawi, and that this quiet diplomacy by Israel could someday also inure to Israel's benefit. In conclusion, I believe that the
and then we'll move to the questions. Yeah.
Lawyers and jurists has a role to play in combating the global political pandemic and the pandemic of impunity. One, unmasking and exposing the culture of criminality and corruption and the impunity that has underpinned it. As Andrei Sakharov used to say, the mobilization of shame against the human rights violators. Second, by taking up the case and cause of the Uyghurs, the worst human rights assault in contemporary times, taking up the case and cause of a situation where we are witnessing at this point acts constitutive of genocide. Third, taking up the case and cause of Nasrin Sotoudeh, who, as I said, is the embodiment of the struggle for human rights in Iran. And indeed, while Israel has spoken often of the Iranian fourfold threat, the nuclear, the terrorist, the regional hegemonic, the incitement, it has not spoken sufficiently of the assault on human rights in Iran. I appreciate that Iran's enmity towards Israel may not necessarily, in fact, invite any positive reaction from the Iranian regime should Israel speak up on behalf of Nasrin Sotoudeh, looking glass into the assault on human rights in Iran. But in engaging with that, it can help to unmask and expose the assault by Iran on its own law and its own treaty obligations. The IJL could also take up the case of the imprisoned Venezuelan judge Maria Lourdes Afiuni, whom I mentioned, and finally to take up the case and cause of Raif Badawi and the imprisoned human rights defenders. Finally, I would be remiss if I did not mention very briefly 2 other concerns. One is the repatriation of the bodies of the fallen soldiers, Hadar Golden and Oren Shaul, and the 2 missing civilians, whose lack of repatriation of the bodies and whose detention of the civilians constitute a standing assault on foundational principles of international human rights law regarding the right to information, the right to truth, the right to repatriation of the fallen soldiers, and the right to accountability. And the international community, as trustees of international human rights law, has to be called to account on this and not be a bystander community to these violations. The second, and it was mentioned so compellingly and so brilliantly by Ilan Carr that I will not repeat anything other than to just reaffirm all his lessons, but only call for one thing, that Israel should appoint a special envoy respecting combating anti-Semitism so that it could become part of the community of nations that have themselves designated special envoys. In conclusion, we must see it as our individual and collective responsibility, distinguishably so as the IJL, to speak on behalf of those who cannot be heard, to bear witness on behalf of those who cannot testify, to act on behalf of those who are putting not only their lives, not only their livelihood, but their lives on the line. This is what the pursuit of justice is all about. This is what tzedek tirdof is all about, and this is the mandate and mission so compellingly implemented by the IJL. Thank you.
Thank you very much. That was fascinating. And by the way, in the chat, it is written. That is great. This is fascinating. I couldn't stop you because it was so interesting. So, a few questions. The one with regard to the ego wars. So, someone was wondering, why don't Muslim countries protest more to China about the persecution of their own co-religionists, because these are Muslims. Another question with regard to the ICC is, do you have connections? How can one impact the ICC in the directions that you mentioned? And another question is, can you describe how the anti-Semitism that we see today is also part of the pandemic of impunity? Isn't the demonization and growing exclusion of Jews, particularly Jews who express pride in their Jewish national and ethnic heritage, a form of national and ethnic origin discrimination and a human rights violation? And another question with regard to the two soldiers, the deceased soldiers, Goldwasser and Adar Goldwin, what efforts are being done in the international arena? So a bunch of questions. We only have 4 minutes. The floor is yours again.
Thank you, Pinin. I'll try to be brief. With regard to why other Muslim countries are not standing up and supporting the Muslim Uyghurs, regrettably, there has been, as I say, not only a pandemic of impunity, but Xi Jinping's China has managed really to bully countries individually as a result of their economic leverage and political leverage and the like. And this has resulted not only with regard to Muslims not standing up, but other members of the international community themselves not asserting this case and cause. 6 months ago, we formed the first ever interparliamentary alliance on China. I'm one of the co-chairs from Canada, the hope being to begin to reverse this asymmetrical power relationship. One of the first cases and causes that we've taken up has been that of the mass atrocities against the Uyghurs. And gradually we're beginning to see Muslim voices also being engaged. Recently, I was part of a webinar that was co-sponsored by the Jewish law students and the Muslim law students at Harvard Law School. And this is one snapshot of increasing Jewish and Muslim groups working together in common cause with regard to the Uyghurs. And here I invite, as I say, the IJL to lend its own supporting and effective advocacy in this regard. In the matter of the ICC, I was one of a number of 6 international lawyers that did file an amicus brief before the ICC, whose main argument effectively was that the ICC simply did not have jurisdiction in this case. And I think and I know that the IJL also intervened in the case. I think it's important that the issue be not one of support for Israel or not, but that what is at issue here is the integrity, the independence, the impartiality of the ICC. And that is why I used Venezuela as a looking glass into the double standards here. And therefore, those who care about the ICC as being a successor court of final jurisdiction to Nuremberg, we're now meeting on the 75th anniversary of the Nuremberg trials, we need to return to that notion of independence and integrity and impartiality of international tribunals and all those associated with it. And the ICC at this point must live up to its mandate and not be appearing to, in fact, abusing that mandate. In the matter of anti-Semitism and the denunciation of Israel, there is a global pandemic with respect to anti-Semitism, a resurgent global anti-Semitism that targets both traditional anti-Semitism and the new anti-Semitism. By traditional anti-Semitism, I speak of the rights of Jews to live as equal members in any society which they inhabit, and that the assault upon and denial of those rights constitutes discrimination against Jews in any community which they inhabit. But the second and sometimes ignored dimension is the discrimination, assault upon, and denial of the right of the Jewish people to live as an equal member of the family of nations. This is the new anti-Semitism. There's no difference between the old and the new in the sense that both share the foundational principle of discrimination against Jews, where the discrimination against Jews as individuals has passed to discrimination against Jews as a people, and Israel emerges as the targeted collective Jew among the nations. And those of us who support the principle of equality, the principle of international human rights, the principle of anti-discrimination, the principle of the right of indigenous peoples to self-determination, must speak up and call out the old and new anti-Semitism, which is anchored in the worst of discrimination, which takes us down the road, as we know, to mass atrocity.
Thank you.
And finally,
thank you, Professor Kotler. I'm sorry, we will have to wait for another opportunity to hear the answer for the first question, because we are out of time, and this was fascinating. Thank you so much for this presentation and for all the work you are doing, and good luck and success in your new position. Your success is our success. It's good for all of us, and we hope that you manage to help also in combating anti-Semitism, Holocaust denial, and continue your good work in promoting human rights around the world. Thank you so much.
Thank you, Pnina, and kol kavod.
After hearing these three, I think, fantastic presentations, maybe I'm not objective, it's now time for a break. So we will return in 5 minutes, and then you will hear from our members of our team, Daniel and Avrumi, about the very interesting work the IJL has done in the past years. So stay tuned and come back after the break. Thank you for rejoining us. I am now happy to invite my friend, Advocate Daniel Reisner, Vice President at the IJL, to talk about IJL at the International Criminal Court. Unfortunately, this time we will not have time for questions after the presentation. So let's first see a short clip about Israel at the ICC, and then we'll hear Daniel.
Israel is getting ready to fight the ICC after the chief prosecutor of the International Criminal Court at The Hague said there are grounds to investigate the state of Israel over its activities in the West Bank and the Gaza Strip. If the examination would deem the ICC indeed has jurisdiction, a long row of Israeli officials, including decision makers and IDF chiefs, might find themselves facing official investigations for alleged war crimes.
This day is a great day for us because we have achieved what we wanted.
Jerusalem is elevating its battle.
Today, the ICC finally became a weapon in the political war against the state of Israel. This is terrible hypocrisy.
The announcement came against the backdrop of an official opinion submitted by Israel's Attorney General declaring that the ICC has no jurisdiction over those territories.
Hello and welcome, dear members and friends and supporters of the IJL. It is a real privilege and pleasure to appear before you today, although it is a slightly odd format given the strange times we are currently living in. My intention in the next few minutes is to give you an update on some of the important legal cases that we have been handling, and primarily the case before the International Criminal Court. But I will also touch upon another case, a recent case which has been submitted to the US Supreme Court. And the purpose of my presentation is not only to tell you what we've done, it's to tell you how we choose the cases that we pick. I have been honored to serve as the Vice President of the IJL for the last 3 years. I took upon myself this position because of 3 background factors. The first is I had a very long career working for the Israeli government. 20 years in the Israeli military, together with my very good friends Pnina, who you all know, Meir, our president, but also Avichai Mendelblit, the Attorney General, Roy Shondorf, many of the people you just met. All of us served together in the IDF, and we were privileged to do so. But I also spent another 20 years serving as the Israeli government's legal advisor to the peace process with the various neighbors. And this is a flame which never goes out, serving the country. The second reason is personal. My father and his family fled Germany in the early 1930s after witnessing firsthand the rise of Nazi anti-Semitism. They were one of the lucky ones, of course, because they got out before. After arriving in Israel, my father joined a group of similar immigrants to establish settlements in mandatory Palestine, and later joined the Haganah. And in the 1948 Israeli War of Independence, my father served as a major in the Alexandroni Brigade. And the third reason I took this position is because I am blatantly and unashamedly a Zionist. I believe in the state of Israel and the Jewish people, and I am proud of it. So serving in the IJL has been an opportunity to further all these agendas, to continue to serve the interests of the state of Israel and the Jewish people, and to stand up and hopefully prevent injustices like those suffered by all of our families. So, how do we choose when to intervene in the IJL? And there is no mathematical formula, but we do have, I think, 3 criteria. Criteria number 1, there needs to be an element of unfairness. Someone must be doing something which violates our feeling of fairness and decency. The second criteria is that there must be some serious consequences or danger as a result of that activity. And the third criteria is that we are not talking about a political position, but a professional position. We are not a political organization. We are a professional legal organization. And that brings me to the story of the ICC. As you heard so eloquently from my friend Roy Shondorf, he explained the background to the proceeding and the status of the proceeding. So I want to give you the IJL's perspective on the process. When the pre-trial chamber issued its call for submissions, we immediately decided to get involved. And what we did, we set up a team of 5 lawyers, 2 external experts, you may know them, Joshua Kern from the UK and Dov Jacobs from The Hague, and myself and 2 of the lawyers from my department at the law firm I work in. And we actually submitted the request for leave to submit to the ICC pre-trial chamber, and we were approved, and consequently we submitted our own amicus brief, our own submission, our own observations to the court. And if I want to focus on what the main issues that we highlighted for the court, I think we highlighted the following 3 things. 1, we said, the court, you do not have jurisdiction over this case. No matter what the prosecutor is saying to you, you do not have jurisdiction. And you do not have jurisdiction for a variety of reasons. One of them is that Palestine is not and has never been a state. And that has incredible consequences in international law in general, and with respect to the International Criminal Court in particular. 2, under the Oslo Peace Accords, which I helped negotiate, the Palestinians do not have any authority over Israelis, and therefore they could not delegate such authority to the court. And thirdly, and perhaps most importantly, in order for a case to be taken forward by the court, there needs to be a level of certainty about the facts of the case and the jurisdiction below which the court has no authority. And we tried to show, and I think we succeeded in showing, that no such certainty exists, and in fact, the question marks greatly overpower the exclamation marks in this case. So, why did we choose the ICC case? I think it's obvious. Unfairness. What's more unfair than going after Israel, the country which actually invented the idea of universal jurisdiction, the sole country in this part of the world which actually advocates compliance with international law and dedicates incredible efforts. And Pnina and I spent many years of our lives focused on implementing international law in military operations. What could be more unfair than that? Dangerous, of course it's dangerous, because if the International Criminal Court were to decide to move forward with this case, it could have significant practical and legal consequences for Israeli leaders and the State of Israel itself. And finally, this is obviously a platform for legal argumentation, which is what we do. And that is why we chose to intervene in this case, and that is why we invested so much time, effort in submitting what we hope was a very professional document. So we are now waiting for the pretrial chamber's decision, and they are taking their time. And if you ask my opinion why they're taking their time, I think it's because of three reasons. One is more than 1,000 pages of submissions from over 40 parties have been put before the court. This is a significant, unprecedented body of legal argumentation. Two, we cannot discount the impact of COVID-19 pandemic on the court's work. And three, and probably most important, this is an incredibly hot potato. And we heard earlier the explanation about the sanctions that the US administration has imposed on the court and the prosecutors if they decide to move forward with this case. No visas, no travel, etc. So the judges are obviously under a lot of pressure to come up with a solution. So we are now standing by to see which way they go. Should they, as we hope, decide to accept our position that the court has no jurisdiction, then we will be happy to have done our bit in promoting justice and equality in the international arena. But if they decide to go the other path, then of course we stand ready to continue to do our work to show the fact that Israelis and the Jewish people stand for law and justice, and we won't accept any attempts to violate international law targeting us. But before I close, I wanted to share with you another case, not a small one, but a recent one which we just decided to assist in. A few months ago, I was contacted by our affiliate organization in the United States, the American Association of Jewish Lawyers and Jurists, and their president, Stephen Greenwald. And Stephen told me that their organization had decided to submit an amicus brief to the US Supreme Court on the question of whether or not the US courts have jurisdiction to address a question of reparation for Jews from Hungary who were deprived of their property during World War II. And we immediately decided it passes our three tests. And we agreed to join. And we connected them to one of our IJL members, Gabor Damjanovic, a very senior Hungarian lawyer who helped them. And the amicus brief was submitted to the US Supreme Court just a month ago. And these two examples are here to show you how you, current and future members of the IJL, can help us promote these type of goals, to take a stand before inequality and injustice, and to speak loudly and professionally in the face of those people who seek to demonize Jews and to delegitimize the State of Israel. With your assistance, we hope to continue to do this for many years to come. Thank you very much.
Thank you, Daniel. And now I am proud to invite Advocate Avromi Ijl, the head of IJL Legal Center for Combating Anti-Semitism, to talk about combating anti-Semitism and Holocaust denial in the global era. Again, we will first see a short clip, and again, unfortunately, we will not have time for questions.
6 attacks against Jewish people this week.
A string of hate crimes against Jewish people.
Anti-Semitism is once again on the rise in Europe.
Good evening, and thank you very much, Pnina. It's a great privilege to stand here tonight and talk about our legal center for combating anti-Semitism, which is now about 2 years old. As Mayor Linzen said in his opening speech this evening, we continued this year under COVID-19 situation. We did the best we could, but we continued combating anti-Semitism, especially in Europe, some cases in court, incitement in the social media, especially in Germany. I'll talk about that a bit later. And we're now preparing, as the Mayor also mentioned, for a very big new project of legal assistance for Jewish communities. We think that if we will be spread out enough, this will create a change in Jewish life and give more security for Jewish people in the diaspora. So those are our plans for the next year, among others. Before I start, I would like to share an important achievement we had just 2 weeks ago. It's in a great timing because we took upon ourselves to join this case of Professor Bilevich, who is from Warsaw, and he was sued by a Polish artist that creates anti-Semitic drawings, etc. And Professor Bilevich said these art drawings are actually anti-Semitic, and he is an anti-Semitic person, and he was taken to court. So Alexandra, who is a board member of the association, 2 years ago in Rome, came up with the idea that we help in protecting him, and we did. And just 2 weeks ago, she told us we won the case. So I think it's great news, and it's in great timing. Okay, so now let's talk about the broader idea of how the challenges we have combating anti-Semitism in the global era. So we live in a global village. That's not anything nobody knows. Everybody knows. And that means we have challenges we didn't have in the past because people are, the anti-Semitic actors use the internet for their needs, and it enables them to do many things very fast. They have very high connectivity. They can transfer money. They can transfer ideas. And another problem that we face is that the legal situation in different places are different. For instance, Holocaust denial is forbidden in Germany. It's not forbidden in Great Britain. We'll see how that influences us in a minute. Okay, this is just to understand how forceful and how what a great impact the internet has. This is 60 seconds in 2020. What happens on the internet? You can see it. It's the quantity of the traffic of knowledge, of information, of messages is just beyond all imagination. And this is, of course, a very dangerous tool for our anti-Semitic actors. So what do they use the internet for? So we can see that they use it for propaganda, for incitement, for recruitment, etc., financing, communication. And I want to give you a few examples of the things we met and we tried to challenge. So let's see a few examples. We see many parades and rallies going on, not this year because of the COVID-19, but in a regular year. And it's very interesting because they happen in different places. They usually, or I haven't seen any overlapping, but I did see same groups coming into different places. You can see them one time in Budapest, and then you see them in Sofia, Bulgaria. And you ask yourself, who told them to come at exactly this period? Who paid for their train ticket? Who paid for their hotel, etc.? And we have some answers, but this is one of the things we see, which of course is enabled because of the connectivity, because of their ability to connect with each other. Which brings me to the next example of coalitions of anti-Semitic right organizations. This is an alliance called Fortress Europe. It was established in Sofia, Bulgaria in April 2019, and you see that we have members, a group from Bulgaria, a group from Germany, a group from Hungary, a group from the Czech Republic, and from Poland. And a year ago, there was a delegation of Supreme policemen from Bulgaria and Israel, and I lectured to them about anti-Semitism, and I showed them this picture, which was taken in a park in Sofia, Bulgaria. And they didn't know about it. Why didn't they know about it? Because the law enforcement forces, organizations focus on where they are. Each one takes care of anti-Semitism, if they do, where they are. And they don't have the big picture, and there's a big picture going on, and it's a big challenge, and we're trying to help challenging it, and at least to bring it also to the knowledge of the law enforcement forces in the different states. Last and not least are the online publishers selling Holocaust denial literature. Why is this so important? Because I think the most important battle that we're going to meet in the next years is the battle of the narrative. What's the story that's going to be told to our children and to our grandchildren? And as long as Holocaust denial material is sold very easily on the net, this is an example for one online bookstore that we just knew about just a few weeks ago, and we're trying to do something about it. It was established by a neo-Nazi called Adrian Perbinger. Since 2016, the Leipzig prosecution wanted to indict him. He was never indicted. He's gone. People say he's in Moscow. But his bookshop is alive and kicking, and whoever wants to buy Mein Kampf or any other neo-Nazi or Holocaust denial literature can go online and purchase it in Germany, and of course in other places. And another example is the Castle Hill Publishers, which we've been dealing with for a while. Its founder was in jail in Germany already, and then he went to the States, and he lives in the States since. This is his wife, this is their house. It's her family's house for the last 5 generations. So we can talk about the white supremacists in the United States. And we turned, but with our great lawyer we have in Germany, Stefan Kamper, that also does a great work regarding incitement in the social media in Germany. And also we asked him to turn to the authorities in Germany about this online bookshop. And so what the outcome of that was that the 7th or 8th arrest warrant against the owner. But since he's in the States, and there they have freedom of speech and they can say anything and do anything, so he will stay in the States safe and sound, and we can do nothing about it. So we said, okay, at least shut down this site in the internet. So that they said they would. We've been following that, and we see that the site is still up, and you can purchase this material in Germany, where Holocaust denial is forbidden. And we asked why. So lately we turned to another German authority called the Media State Authority that's supposed to help us in this, in achieve this goal. And just about 10 days ago, I think, or maybe a bit more, we got this letter saying, you're right, it's wrong what he's doing, this site is wrong, but the publisher is based in Great Britain, we'll turn to them. And since, I'm telling you that since Holocaust denial is not forbidden in Britain, the British will do nothing about it. So we'll try to think of other ideas, but these are challenges we face. So it's a long way to go, but we're continuing. And as Daniel said, we're open for ideas and for suggestions for more cases. We'll examine them and we try to bring them out. So thank you very much for your attention, and I hope the next conference will be as normal and we can meet each other again. Have a good day and a good night. Thank you.
Thank you very much, Avrumi, and thank you, Daniel and Avrumi, for showing what we are doing in the IJL. You're all invited to send us any kind of information and to join the IJL if you're not members yet. And before closing this part of the Congress, we want to pay tribute to a beloved member of our association who passed away this year, Advocate Joseph Rubash, Zal, who was involved in establishing the association in 1969. He served as IJL's honorary vice president and the former chair of the French branch. I invite us to watch together Advocate Jacques Cohen, the president of the IJL French branch, who will share some of his memories of Advocate Rubash.
Bien, je suis ému de devoir parler de Joseph Rubash, qui a été quelqu'un d'absolument exceptionnel. Je l'ai connu lorsque j'étais jeune avocat. Je l'ai connu lorsqu'il a créé l'association avec Bernard Cahen, qui à l'époque avait créé le Rassemblement des avocats juifs de France. C'est un grand combattant que nous avons perdu, un homme qui n'a jamais baissé la tête, qui a toujours su marcher vers la liberté et trouver les mots tant pour rassurer que pour convaincre toute sa vie. Il a fait des choses absolument extraordinaires et il est vrai que de reprendre la présidence de l'Association internationale des avocats et juristes juifs pour le comité français est une charge morale très délicate. J'ai toujours apprécié sa tendresse à mon égard. Il a toujours été d'une gentillesse extraordinaire, même lorsque j'étais jeune avocat et que je venais chez lui pour participer à des réunions. Il était toujours adorable et il fait partie de ces gens qui aident les autres en permanence. J'ajoute que c'est un homme il était intimement convaincu du bien fondé de la République, des notions telles que la démocratie. C'est un homme qui était intimement convaincu du strict respect des droits fondamentaux. C'était un homme fidèle, fidèle en amitié, fidèle à ses idées et fidèle à ce que je vais appeler son judaïsme, qui était absolument œcuménique, ouvert sur les autres, tout en restant très précis et très ciblé en termes de judaïsme. Voilà les quelques mots que je pouvais dire aujourd'hui sur Joseph Rubash.
Jacques Rubash, may rest in peace. Thank you, all of you, for watching, and now we will take our final 5-minute break and return for our election session. So, stay with us. Hi, everyone. To preside over the election session, I invite the chairperson of the election committee, Professor Tamar Gidron.
Thank you, Pina. Good evening, everyone. It's a great honor for me to preside over this important task of the election of the organization. I've been watching the organization for a very long time now, and I've been impressed by the important operations and the activity of the association, especially in the international arena and especially in these hectic times. I would like first to thank my friends, the member of the election committee, Advocate David Benjamin, Advocate Rhonda Lee, Advocate Boki Katzman, and Advocate Julia Andrus. According to the association's bylaws, the committee has met online and reviewed the list of members who paid the dues for 2020 before September 22. The committee approved the list, having been satisfied that the said bylaws were really met. Following again these bylaws, members whose names are on this list are qualified to vote and stand for election. Each member on the list have one vote, except the two members who vote for their organizations, Advocate Jonathan Lux from the UK and Advocate Stephen Greenwald from the US. They are both good friends, and it's very nice to see you here. So those of you who are qualified to vote will be asked in a few minutes to kindly review the list of candidates you will see on your screen. Then you will be asked to tick the relevant vote, and then be sure to click the submit button, the blue button you will see on the screen. You will have 60 minutes to do so. When the time is up, you will be referred again to the main screen, and the votes will be counted later today, and the results will be sent to you accordingly. So here we go. Thank you. Thank you all for voting. Thank you for being with us. As I've said before, the vote will be counted and the results will be sent to you accordingly. Good evening, and back to you, Nina.
Thank you very much, Tamar. And now I invite our president, Advocate Meir Linzen, to make some closing remarks.
Thank you for the competition. It was a long evening or a long morning, depends where you are. I want to thank you for the confidence that you gave me to continue my position in the next term. Also, I want to thank on behalf of the other executive members and the board members that were elected today. Thank you for the confidence. As you saw today in live, I am just the conductor of this orchestra, and there are players in this orchestra that are much better players than I am. You saw today in action two of the vice presidents, Pnina Sharvit Baruch and Daniel Reisner, two amazing public international lawyers that each of them contribute a lot. You saw also today our staff member, Avram Yishai, the director of the Center of Combating Anti-Semitism. Behind the scene, you didn't see our CEO, Ronit Gidron Tzemach, and many others that I think developed this organization in the last 3 years. And we promise you to continue in the same passion in the next 3 years. I want to thank very much to all our speakers, both from the government sector and in the United States and in Israel and from the academia. I want to again to congratulate Professor Kotler for his new important appointment as the envoy for fighting anti-Semitism in Canada. He's also honorary member in our organization. I call upon all our members to come with initiative, to be active in legal activity of the organization, to participate in our conferences and helping us with fundraising. And I want to thank for all the people for our audience, more than 350 people in many, many countries, in many continents that participate this evening. And I wish you and your families good health and that we all will live in a better world. Thank you very much.
Thank you, Meir. So, we have reached the end of our first virtual congress and almost no technical glitches. So, I want to thank the wonderful team who made this congress possible. Dr. Mala Tavori, who helped in preparing the program, Avraham Tzur for the wonderful clips we've seen, Ayelet Tal Rothenbach, our producer from Dirigo Company, Ofir Yakim, the technical manager, Iris Padan Zilberman, our administrative manager, and of course, Ronit Gidron Tzemach, without her, nothing of this would be possible. So thank you all, and thank you all for joining us and for watching. Keep healthy and safe, and let's hope we all meet in flesh next time.